Hi, Mr. Khan. How can someone prove 20 years of illegal stay in the UK without having documentary evidence?
Anyone has been living in UK and claim is that 20 years, and rule says that under rule 276B Immigration Act 97(1) says that if someone or applicant has been living in UK last 20 years can apply for leave to remain, not for indefinite leave to remain. That's one thing. So how can prove? Because we do understand that if someone is claiming that has been living here last 20 years, it is less likely that that person or the applicant would have a bank statement, a formal utility bill, this kind of thing is like chance. But what Secretary of State wants to prove that presence in UK. They are not saying that establish the day, they just want to prove the presence in UK. And if there is a valid entry there, for example, how can prove? For example, the applicant came in UK as a visitor, let's say that. So that passport stamp, right? A copy of that particular page of the passport. If passport is there, valid passport, obviously is not valid now. So any original copy of that, the fantastic visa copy. If any air ticket, for example, or however the way that the person entered in the UK, you need to establish the entry. Number one. Number two, for example, if someone has been some social events like been birthday parties, like wedding parties, like other things, these type of photographs are some of the different type of photographs in different places in UK somewhere else, for example, London Bridge or some in Manchester somewhere else. So photographs with friends or with family friends, and so these, so with the small caption. So this type of evidence could be sporting evidence. It won't be a primary evidence, but sporting evidence. If this person managed to open a bank account, bank statements, obviously, if any gas bill, water bill, electricity bill, or gas bill, or any council tax, for example, or any kind of fine. So these type of things, these are the primary evidence. If any tenancy agreement there, so any other stuff, reference letter, especially if someone is the member of some social clubs, a member of, for example, some religious community centers like a mosque or gurdwara or a temple. So the kind of letter from them, if someone is worship on a regular basis going there, a letter from them, a reference letter from the friends, a reference from the families, reference letter from the people all in the picture. So these kind of stuff can prove that the person has been living in UK. But one thing you have to keep in mind when providing us supplying these type of evidence, make sure supply the evidence in the line of every year. It's not just no, every year. If someone is saying, let's say, the applicant came in UK and is claiming that he came in UK in 2015, right, 2005, let's say. So 2005, that entry, and then after that every year something should be there to establish that the person was present in the UK. For example, any kind of a correspondence with the Home Office or any immigration bail or any kind of reporting someone has been reporting in the last couple of years. That's another fantastic document. So it vary case to case. There is no set rule for that, but these are the requirement that rule 276B says that person replicant has to establish that he has been living here in UK last 20 years. If he prove, yes, certainly he can apply for leave to remain, and after 2.5 years he will get another extension, then again 2.5 years extension, then following completion of 10 years, then the applicant would be applied to or would be eligible to apply for indefinite leave to remain. Yeah, before 2012 it was possible to apply indefinite on 14-year base, but now is after 20 years only leave to remain, not indefinite.
Okay, thank you, Mr. Khan.